Hello and welcome to the webinar on evaluation of projects and clients. My name is Judy Mendoza and I'm in the Risk Management Department of Victor O'Shenner. So let's start at the beginning. What is risk analysis? Risk analysis involves an overt and continual effort to identify and pursue possible sources of risk while assessing their probable impact on the project. So, keep in mind, in theory, the sources of risk that could potentially impact a project are virtually infinite in number. But in practice, the number is really statistically significant. In practice, the number of statistically significant sources or risk is relatively small. So today what we're going to do is look at two of the big risks that can impact your services, and that is looking at the evaluation of the projects and the clients that you're going to work for. Effective risk management begins well before you take on the services for a particular client or a particular project. As a design professional, you should be conducting reasonable evaluations of potential clients and potential projects, and then prepare carefully thought out and well-written proposals to increase the odds of having a relatively trouble-free practice. Remember, not all risks can be avoided, but risks can be managed and mitigated successfully when they're addressed in a timely manner as a result of the evaluation process. So today what we're going to do is we're going to look at before you do your proposal, your evaluation of the project and your evaluation of the client, and then your proposal phase evaluations as well. Okay, keep in mind that not every project is suitable for every design professional. Projects should be evaluated from a number of different perspectives, including whether or not the project meets your firm's goals with respect to things like the geographic location. If the project is outside your ordinary area of practice, are you prepared to deal with projects in that area? When I was handling claims, I remember having a few involving, say, Bay Area clients who are used to dealing in a certain geographic area, working on projects, say, in the Lake Tahoe area, and having claims resulting from snow loads because they weren't really familiar with designing projects that had snow involvement. The project type, different project types have different risks, and we're going to go into that in more detail. What is the potential profitability of this project for your firm? And importantly, what is the likelihood that disputes or problems could arise? Some projects are more problematic than others. Again, we're going to look at that. Will this new project enhance your firm's reputation, and potentially will it lead to other work? Those are all things that need to be evaluated. So one of the things, especially if you're thinking of working outside your typical geographic location, is to look at the business licensing of various states. If you practice as a corporate entity and you want to perform services in a state other than the one in which your corporation was formed, you may have to register in that state as what's known as a foreign corporation. You'll have to pay taxes on the income earned in that state, and you're going to have to meet other administrative requirements. Failure to comply could subject you to fines and penalties. If you want to provide services in another state, what you really need to do is early get your involvement of your attorney and your accountant to help you assess the implications of interstate practice and provide advice on how to conduct your practice in accordance with applicable state laws. Another thing that you want to look at is your licensing requirements in each state. You have to meet licensing requirements in each state in which you want to perform services, and not all states will allow all types of firms to offer design services. So generally, if you're a sole practitioner, you can practice in any state in which you are licensed. All states will permit partnerships to offer professional services, but they'll often regulate the name or other aspects of the operation of the firm. Often states may specify the number or the percentage of partners who have to be licensed in that state or elsewhere. Now, a smaller number of states allow for corporate practice of the design professional, but only in the form of a professional corporation or association, generally meaning that all ownership interest in the firm must be held by licensed professionals, and all services must be performed under the responsive supervision of licensed professionals. Most states will allow general business corporations, partly or wholly owned by non-licensed individuals, to practice the design profession as long as they do so through an employee who is licensed to practice the applicable profession in the state. It all sounds rather confusing, but they are hoops you need to jump through because, one important consequence of practicing improperly is that you may be denied access to the courts of that state if you need to sue for unpaid compensation or to resolve any other matters that may be in dispute. So it's maybe onerous, but it's important to do so because you want to have the right to be able to operate legally and have access to the court should you need it. Okay, so let's start looking at, what type of project are you contemplating taking on? Our statistics show that houses and townhouses result in the most claims against both architects and engineers in our program. But condominiums result in the highest severity, meaning the most amount of money paid out for architects, even though they're also a significant factor for engineers. Hospitals and schools have considerable claims histories, and for large engineering firms, highways and bridges create the most claims. We're going to take a little bit deeper dive into these various projects. Other factors that you want to think about when you're taking on projects are things like, what is your scope of service going to be? If you have a limited scope, that typically will result in more risk. How complex is the project? Obviously, again, the more complexity, the higher the risk is going to be. And are there specific laws and regulations that apply to the project? For example, getting back to the hospital projects, hospitals tend to have a lot of rules and regulations in place, and you need to be familiar with them to have a more risk-free type of project. We also have a ton of various claim studies available on our website for our policyholders. These claim studies, there are probably over 100 of them, and they touch on just about every type of project, as well as various services that are provided and your disciplines, and what kind, there's just a ton of information that can help you make that decision before you proceed to take on a new project. You also want to look at things like, what is the design delivery? Is this a traditional design bid build, or the more traditional, I should say, design bid build, or is it design build? Obviously, if you're the design builder, you're going to have enhanced exposure to claims for bodily injury, property damage, and economic loss, and you'll be responsible for construction means and methods, as well as job site safety. Typically, that's not the role that a design professional takes in design build, but we do sometimes see it, especially with larger firms. You want to look at a project and determine if there's one general contractor, is there a construction manager involved, are there perhaps multiple prime contractors? Again, keeping in mind that the presence of a construction manager adds another party, and that can lead to more fragmentation of the project delivery method. Multiple primes can increase scheduling and coordination issues. I just remember when I handled claims, seeing many more claims where there were construction managers and or multiple primes involved, because it has to be really clearly delineated as to who is corresponding with whom, who has what responsibilities, so things don't fall between the cracks and they don't get too complicated that way. Another consideration is, will the construction documents be completed prior to construction, or will they be completed in stages while the construction is still going on, otherwise known as fast track? Our statistics have shown that claims that are being designed in a fast track method do tend to result in more claims than a more traditional where your construction documents are completed in advance. We have a ton of benchmarking information available on our website. I'm not going to go through all of it with you, but I thought I would at least share some of the benchmarking relating to project types to give you an idea of what's there. So this first chart is a chart showing architects only, not the engineers in our program, nationally, so across the country, and all sizes, small, medium, large firms. What it does show is that, and let me just also clarify that the darker blue line that you see is frequency, meaning the number of claims that are made against an architect involving these projects, whereas the lighter blue line is the severity, the amount of money that we pay out on behalf of architects on these type of projects. So, of course, probably the first thing you're noticing when you look at this graph is that the most money is paid out on condominium claims, and that's probably not a surprise to anybody. And yet the most claims in far of numbers result from houses and townhouses. One thing we always suggest looking at when you're looking at a chart like this is when the severity far outweighs the frequency as it does in the case of condominiums here. That's usually a red flag. That's telling you that this is perhaps a more dangerous kind of project than others. And this is probably a good time to talk a little bit about, why are condos the most expensive claims that we see? Why are they so risky? And, one reason is that your client and the ultimate user are often not the same. Users may have very different goals and requirements from your clients. Because developers, your clients, are focused on low construction costs, and that's sometimes at the expense of life cycle cost increases. So the ultimate users, the purchasers or the ultimate users of the unit, may complain about the quality of construction or high operating costs because that wasn't something of concern to the developer, who was your client. Another thing to consider is that one design error can show up in every unit, and that totally magnifies what may have been a small problem. So, for example, if there's a $1,000 error that you made in a unit, and if that was a single residence, that might not be a very big deal. But if you're talking about a 250 unit condo project, now you've got $250,000 claim because of that one small error. So it's almost like a class action suit is developing. Another big issue with condominiums is who is your client? What type of developer are you working for? Many times the developers disappear before the litigation begins. So you want to make sure that and we'll talk about that more when we talk about analyzing your clients. But, you don't want to work for some fly-by-night developer who created an LLC just to work on this one project, has never done any other projects in your community before, and is going to be gone as soon as the project is finished, because then there's nobody there to help you if the lawsuits start coming in. Now, some of you may decide to avoid these type of projects altogether. Others of you will accept the risk because you've learned how to manage it, and partly because the rewards are perceived to outweigh the risks. That's an analysis that you need to do on an individual basis. The risks associated with high-risk projects can be mitigated by perhaps obtaining higher fees to pay for the cost of that mitigation. And also remember the importance of excellent documentation of recommendations that you make to the clients. Document the client's instructions and decisions to either accept or reject those recommendations. If a claim does come down, you need to be able to prove to the trier of fact, be it a mediator, judge, jury, whoever, that you met your standard of care, that you did your due diligence, that you made recommendations, the client, for perhaps cost reasons, didn't accept them, and you pointed out why that could be dangerous and they went ahead anyway. That should help relieve you from some of that liability. Now, we also have charts, just to run through them fairly quickly, for various size architecture firms, and we'll go through the same thing with engineering firms. So this is a chart that relates to large architecture firms, which in our definition, a large firm is a firm with annual billings of over $5 million. And you can see that even for large architecture firms, again, condominiums are still the type of project that results in the most dollars paid out. But you'll also notice that now schools and colleges have come in as the type of projects that create the most claims against large architecture firms, something to keep in mind. If you look at mid-size architecture firms, and these are defined as firms that have annual billings between $500,000 and $5 million, again, condominiums by far the highest for severity and also for frequency, followed by schools and colleges, and you can go down the line or go online and look at these in more detail. We also have these type of charts that will break this down not only by architect versus engineer and size, but also by region of the country. So you might be interested in looking at how claims in the Midwest differ from claims on the East Coast or the West Coast or the Southwest or whatever. If you have any trouble accessing that information, let us know. We can help you get to it. It's all on our School of Risk Management. And this is small architecture firms. These are firms that are below $500,000 in billings. And again, you can see for them, primarily houses and townhouses create the most claims. It's probably the most project types that they're working on. And again, there's that red flag of condominium, that light blue line being higher than the dark blue line. Here are the graphs for engineers nationally. By all and this is all sizes. So again, houses and townhouses have the highest frequency and severity, followed in severity by schools and then condominiums. We've also broken down engineers into the large engineering firms where, as you can imagine, larger firms are doing probably more highways and bridges projects, and they do result in a lot of claims. One of the reasons for that, unfortunately, and we've got a really good claim study on highways and bridges claims, is because very often the engineer is working for a government entity that may have sovereign immunity, meaning that no claim can be made against them, or sometimes there's limits to the amount of damages a governmental agency may have to pay out. It may only be $250,000. So we've seen a lot of claims, sadly, where you may have a drunk driver who's driving excessively fast and recklessly, has a bad accident, kills or severely injures himself, passengers in the car, perhaps people in other cars, and has either no auto insurance or a very low policy limit for their automobile liability coverage. And so these people who are, badly injured, or the estates of the people who have been killed in these accidents, may not be able to go after the owner because it's a governmental agency with sovereign immunity. They may not be able to go after the driver because there's no insurance and possibly no assets. And unfortunately, the only party left to go after is often the engineer. And even when there's no liability, if you're looking at the possibility of going to trial with people who are severely injured, and it's very expensive to do that, you may make the decision to settle the claim rather than face the risk that you could get a judgment that far exceeds even your policy limits. So it's kind of a risky situation and something that should be anticipated and considered by firms before taking on those kind of projects. I'm going to kind of just quickly go through the rest. This is mid-size engineering firms, again, townhouses, and now you're going to see land and site development coming in as the project types that create more claims. And small engineering firms, again, houses and townhouses are rather significant. Okay, again, all of that is available on our website, which is why I didn't want to spend too much time on it. So we're going to now talk about what's the type of construction contract. And that is because contractors can and do file claims against design professionals. Now, it depends on the law in the specific jurisdiction as to if there's an economic loss doctrine that may prevent a contractor from filing a claim directly against a design professional. But, whether or not that doctrine exists, eventually the claims are going to get to you if a contractor has a large claim. So whether they can make the claim directly against you, let's say they have delays or extra costs and they want to go after somebody for it, they might make the claim against their client, the owner, but then the owner will turn around and bring you in on a third-party action. So you don't have a lot of protection, really, from claims by contractors. This can be mitigated by analyzing in advance. For example, before you start even accepting the project, do you know who the contractor is going to be? If you do, and it was a positive experience, this will greatly reduce the risk factor. If you don't, then it increases the risk of proceeding with the project. You don't know what their experience is going to be, what their funding is, if they have bonding in place. So it just kind of increases what the risk could be on that particular project. Historically, we find there's more potential for disputes on projects that have been competitively bid rather than negotiated or a cost-plus fee kind of contract. Contractors who are awarded a fixed price contract based on a competitive bid have a strong interest in doing the work, obviously, as inexpensively as possible, and in doing the minimum amount of work that will meet the requirements of, and be accepted by both you and the client. That's the way the contractor can maximize profits within the fixed contract price. So you and your client want to work, you and your client want the work that's designed and specified without a reduction in the amount of quality and without claims. And so there's a difference in interest between you, the client, and the contractor, and that can lead to inherent tension in the relationships, and that can often result in claims as well. Client-contractor disputes tend to involve the design professional. They will often be alleging that your documents were incomplete or ambiguous, or you provided poor construction contract administration services. And the situation is exacerbated because it's often difficult to limit the bidding on some projects to contractors who are appropriately pre-qualified. So it's harder to predict the contractor's ability and experience. Now, obviously, you're not going to avoid all projects that are competitively bid, but knowing that the risk, allows you to adjust the amount of detail in your drawing and specifications, perhaps to minimize questions and disputes during bidding and construction. And also be aware of the need to communicate and document your fair and objective administration of the construction contract. Keep the client advised of what the contractor is doing or not doing. One area that we always think is kind of interesting is that you have a great relationship with your client often during this whole pre-construction phase. You're working together on the design, and then a contractor comes into it and into the mix. And contractors go to seminars that are similar to these type of seminars. And they are taught to establish that relationship, take the client out to breakfast every morning, start perhaps complaining a little bit about the design documents and that, that they're not as clear as they should be, or that there's ambiguities or incompletions. And contractors start getting that bug in the client's ears. And it's some unfortunately, design professionals fall back a little bit during the construction phase, and they're not maintaining that relationship with your client. And you need to do that. You need to have a good kind of bedside manner with your client to constantly keep your client advised as to what's going on and answer their questions and be responsive. The better relationship you have, the less chance there's going to be a problem down the line. So now we're going to talk about the pre-proposal evaluation of the client. You obviously can't work for every potential client that calls you, so you need to consider a variety of client characteristics to assess whether or not you're able to meet the client's needs regarding things like quality and schedule, and the client's ability to meet your needs, appropriate compensation and professional satisfaction. This is the time where I would say it's really important to listen to your gut. I can't tell you how many times when I was handling claims, an architect or an engineer would say to me, I knew I shouldn't have worked for that guy. Something told me he was going to be a problem. Well, if something is telling you that in your gut, that may be the time to really step back and decide, do you actually want to take on the project and work with this guy, or person, I should say, or is it a project where there's just so much risk that you decide you're going to employ that risk management technique known as avoidance and just walk away from the project? Or you may decide that you're going to still work for the client, but if you're aware that there's increased risk, that's where you need to kind of mitigate what could happen and do a better job of communication and documentation and perhaps detail in your design, and do everything that you can to try to increase your relationship with the client. So let's look in a little bit more detail about that. First of all, I would say, why is it so important to analyze who the client is? Well, as this graph shows, 63% of claims made against policyholders over 10-year periods were made by the project owner. And ever since I've been with Genera over 20 years now, this graph has pretty much stayed the same no matter what 10-year period you're looking at. The majority of claims against design professionals are made by the project owner. And this is really not bad news from a standpoint of the design professional, because if you look at this graph, you'll also see that 8.4% of claims were made by the general contractor and 2.5% of claims by subcontractors. And then if you add in claims involving worker bodily injury, you're at 78% of claims being made by owners and contractors against the design firms. These are entities with whom you've got a working relationship. You could try to manage these relationships. There's not a lot you can do about the unknown third party who may walk past one of your projects and trip and fall, or an adjoining property owner who has damage as a result of the project. But you can, from a risk management standpoint, try to manage the risks of the parties with whom you have a working relationship. And choosing the right client certainly can help reduce that risk significantly. The other thing to keep in mind is it's also not just even who is the project owner, but if you're a subconsultant, you need to still analyze the risk of the project owner as well as what are the risks of working for whoever it is the prime designer in that particular case. Or if you're working as a subconsultant to a design builder, you want to analyze the risk again, not only of the potential owner, but also of your client, who in this case may be the design builder contractor. Um, so you want to go through this whole analysis for each of these entities to make sure that you're managing the risk in the best possible way. And if you see a problem with that's developing for the owner and you're a subconsultant to somebody and you feel that it isn't being addressed by the prime, you need to try to deal with that in any way that you can. When you're a sub, I know you have less control over managing the expectations of the owner, but you have to try, especially if you see that there's a problem that isn't being addressed by the prime. So these are the items that you should consider when you're evaluating the client, and we're going to look at each one in a lot more detail, starting with the track record. Well, one way to try to figure out what is their litigation history and what is their attitude towards quality and cost, and do they pay their bills promptly, and all of these, is to discuss the prospective client, perhaps with your colleagues, even with some contractors. You want to find out what the client's litigation history is and their attitude about quality and cost, especially with developers or corporate clients who have continuing building programs. This could also be helpful even with infrequent corporate or institutional clients. Were their bills paid promptly? What is their attitude toward risk allocation? Are they the kind of client who believes that all risk should be shifted to other parties, or are they more realistic and understanding that as the project owner, they have control and ultimately they're going to make the most money on the project and that risk should be fairly allocated? You'll start understanding this when you get into that early project negotiation, but you kind of want to, the contract negotiation, but you really, I think, want to know that even before you get to that stage. You want to look at what kind of client are you working for. One way to delineate clients is what we refer to as the naive client versus the sharp client. And that's not a judgment of any type. There are pros and cons to both types. Naive clients, and by this we mean the kind of client who is not a very experienced client when it comes to design and construction. Maybe this is their first project they've ever worked on. They don't really understand what the rules are. They're going to need a lot more hand-holding and explanations. They may have unrealistic expectations. Everything's going to be perfect. There are going to be no additional cost. It's going to come in early, perhaps. You've got to manage their expectations. They may have inadequate financial resources. They may be prone to disappointment. You need to make sure that they understand the implications of various decisions and the approvals that they give you. I have to say my greatest lesson that I learned, probably the best piece of risk management advice that I can give you from my experience of handling claims, is the importance of managing your client's expectations. If your client has a level of expectation that exceeds what you're providing to them, even if what you're providing meets or even exceeds the professional standard of care, keep in mind if there's a gap between what you're providing and what your client is expecting, you're going to have an unhappy client. And an unhappy client is going to result in a dispute or possibly a claim or even litigation. So the importance of managing your expectations, constantly just check in, make sure they're happy, make sure they understand what's going on. Now, on the other hand, other than the naive client, you might have the sharp client. This may be the professional developer who does lots of projects, and they're the kind of client who's going to possibly try to shift all of that responsibility away from themselves and onto the other parties. Sharp clients may insist on that you take an equity interest in the project. They will very probably have unreasonable contracts that include things like broad warranties and guarantees and indemnification clauses and provisions that increase your standard of care. You need to look at those carefully and understand what you're agreeing to, or if you're not going to agree to it. Here's an example of a claim that I remember handling once, where it involved an interior designer who agreed to work for a client who loved to sue people. He sued everybody. He sued other service providers, business associates, and even numerous ex-wives. He was a very well-known, wealthy person. I'm not going to tell you who he was, But he did retain this interior designer to work on his mansion down in Palm Beach. And he didn't like the antique French floor that was moved from France into his estate from a chateau in France. And of course, it took him no time to file suit. Now, despite the fact that the interior designer had some excellent defenses, for example, there was water infiltration coming into the estate from improperly installed doors that caused a lot of the damage. There was some shipping issues with the way the floor was protected during the shipment. And then, of course, there's the impact of Florida humidity on a wooden floor. But he refused to budge from his demand of $1.8 million. And it was estimated that the cost of taking this case through trial would perhaps exceed $400,000. So it was a very risky proposition. What we finally ended up doing was being able to track down one of his ex-wives, who was not real happy with him anyway, and she had been with him in France when they first discovered this floor, and she was willing to testify that the floor was in basically the same condition when it was in France that it was when it got installed in his mansion in Palm Beach. That helped us resolve the claim. It eventually settled for $235,000. Sadly, the interior designer had to waive her $70,000 fee, and we also paid about $250,000 in legal and expert fees. So not an inexpensive thing, and again, all because of working for a client who perhaps she should have known was going to be a problem. The other thing you want to think about when you're thinking about what type of clients they are is also just to analyze, is it a public client or a private client? Is the client a committee? Committees can be very difficult to work with because over the course of the project, from when you first get retained on the project till the project is completed, people come and go on the committee. So often the people you're working with toward the end are not even the same people who were involved in the beginning and made the decisions. So when you're working with committees, you need to really document every discussion that's gone on and decisions that were made. So, there's not a lot of finger pointing when people come and leave. And there may be disagreements between the committee members, which makes it difficult. Remember all those claims against the smaller and mid-sized firms for houses and townhouses. Keep in mind that even a husband and wife could be considered a committee. Often they have different ideas of what they want and may give you different instructions. And so that there needs to be, as much as you can, try to determine one clear decision maker and try to go with what that person says. Okay, you also want to look at the financial capability and integrity of your potential clients. It's interesting to think that you're extending credit to your client when you begin your work. Even if you've gotten an advance payment, typically 2 months worth of effort and expense are performed or incurred prior to the time your first invoice, which is frequently sent out at the 30-day mark, will be due for payment, and that's frequently 30 days after it's sent out. So you're really extending credit for 60 days to your client and hoping you're going to get paid for it. So at a minimum, you want to check the credit rating of your client. You can do that through things like Dun & Bradstreet or Experian.com. You can ask your client for financial statements. You might even be able to ask your bank to call their bank. But there are things you can do, and you need to check their credit. If it's a government client with a publicly funded project, you've got different challenges, but you at least want to verify that the money appropriated for the design services are available. Excuse me. So here's an example of what can happen if your client doesn't have the financial capability. In one claim that we handled, a small town retained a civil engineer to design a new sewer system. The town wanted additional components and kept adding things, and eventually, of course, they ran out of money. The town ended up suing the engineer for cost overruns of $1.2 million, and the engineer was still owed fees of $350,000. Although there was no liability on the part of the engineer, the town couldn't release their claim as long as they still owed fees to the engineer. So the engineer was finally forced to compromise his fee claim, accept only a partial payment from the town's insurer, and then collect the remainder fees over a period of years. Not a great resolution. Make sure there's enough money set aside for your projects. Claims history. Just as projects have certain claims history associated with them, so do clients. Some clients are just more litigious than others. If you can, check the court records in your area or in the client's home area to determine how many suits your client may have been a party to. Unfortunately, arbitration cases and settlements aren't a matter of public record, but your attorney may be able to informally determine the reputation of the client in this regard. Your attorney may have heard things or may have even worked with that client before on representing other design professionals. Word of mouth among your colleagues is also very valuable. For example, we are aware of one commercial entity that had a practice of advising its franchisees not to pay the final invoice of the design professionals who were hired to design the retail stores. Their attitude was that there was probably something to question, and the amount of money was often not enough to litigate over. So therefore, the amount was dropped directly into the client's bottom line as profit at the expense of the design professional. Now, if you are aware of something like this, it could affect your proposed compensation and payment terms, if not other aspects of your relationship with that client. So you need to know in advance how your client is going to react and are they going to pay your bills or not. And what is their approach to professional compensation? Some clients solicit bids as part of the process of selecting design professionals to be hired on a project. Others are willing to negotiate compensation with you and select you on the basis of professional qualifications, the nature of the project, and the extent and type of services and the costs. That's qualification-based selection, which we think is a far superior method to soliciting bids. Design professionals, you are not fungible commodities. Fungibility is an economic term that refers to a good or a commodity whose individual units are essentially interchangeable. For example, since 1 kilogram of pure gold is equivalent to any other kilogram of pure gold, whether it's in the form of coins or ingots or any other state, gold is fungible. Design professionals are not fungible. Each of you brings to the table a unique experience and ability. When you consider that your client is buying your skill and judgment, it's obvious that a system that focuses on qualifications is more likely to produce a suitable matching of the client, the project, and the design professional. And since the design professional services are such a small fraction of the life cycle costs of a project, focusing on the cost of these services is really generally not justified, even in economic terms. Clients who solicit bids for services may be raising a warning flag for you. Why are they doing that? Are they short of funds? Are they cheap? Do they just not understand the nature of professional services? It may lead to tension. So frank discussion with your client may help understand that, or perhaps through the terms of your contract. Another example was an architect who agreed to design a condominium project for a developer that was new to town and had no ties to the community. The developer's emphasis was on cheap, fast construction with little concern for quality. He paid low fees and refused to allow the architect to provide construction contract administration services. Several years after the units were sold, the Homeowners Association filed suit alleging numerous design and construction defects. The developer had left town and did not have insurance. Despite minimal liability, the design team contributed over $2 million to settle the claim. That's what we talked about earlier with analyzing who that client is and are they going to be around, especially with condominium claims, because, another point that I didn't bring up earlier when we talk about why condo projects are so dangerous is plaintiff attorneys who target condo projects like to wait as long as possible to sign up their clients and file litigation. They will kind of edge as close to the running of the statute of repose in whatever jurisdiction they're in. In many states, that may be 10 years after substantial completion. Their theory being the longer they wait after substantial completion, the more problems are going to have occurred, especially if there's a lack of maintenance or interference by the homeowners association of how the project was designed originally. And so the longer their laundry list, the kind of easier it is for them to make the claim, and the larger their claim is going to be. So you really want to, as much as you can, make sure that that developer is going to be around and accountable even 10 years after the project is completed. I know that what some design firms do is they insist that their developer put money into a special fund to pay for maintenance, perhaps over the 10-year period, and maybe another contingency fund to pay for claims that may result. And if your a desirable design professional and that developer wants you, they might, they're often more willing to set aside that money because they know they won't get you otherwise. And I've seen many firms who are able to convince their clients to do that. Okay, so now we're going to move on to the proposal phase evaluation. This is the unofficial commencement of contract negotiations. And frequently, the essential elements of the eventual professional services agreement are established at this time, and that shouldn't happen without adequate thought. Very often you'll get that RFP, and frequently it will contain, here is a sample of the professional service agreement we're going to ask you to sign eventually. And there are some interesting problems that can create for you. But let's start by talking about your firm in relationship to proposing on a new project. When you're considering and preparing a proposal for a new project, you need to objectively evaluate whether your present staff is large enough to handle the project. If there's rapid growth, which can stretch trained supervisory personnel to the limit, that may contribute to quality problems. It may indicate that more time and money will have to be allocated to the project to compensate for the introduction of new staff members. So good news, are you so busy that maybe you don't have the capacity right now to take on a new project? Or are there services that are going to have to be provided on this project that your firm is not qualified to provide, and therefore you're going to need sub-consultants to help you? We'll talk about that in a second. You also want to evaluate the experience of your staff with the size and type of project that's under consideration. If your firm has a long history of doing school projects, it may be exciting to consider a hospital project, but you have to recognize that there's a greater likelihood of problems. So if you recognize these risks and you take steps to address them before the problems arise, there's no inherent reason not to pursue new project types. Just recognize that if they're new to your firm, there's going to be a learning curve, and you need to perhaps set aside more time and a little bit more money to make sure that you're up to speed and that you're meeting the standard of care for those projects. Now, we talked about, I mentioned hiring consultants if you need to for a particular project. If you're retaining consultants, you want to make sure that they are the right type and depth of experience for this particular project. Also, can they handle the workload and the time available? What is their capacity? Are they likely to have problems with growth? One of the biggest things you want to make sure of with consultants is, are they adequately insured? I'm sure most of you are aware that as a prime designer, when you retain a sub-consultant, you have what is the law refers to as vicarious liability for the negligence of your sub-consultants. So if a claim arises and it was the fault of your sub-consultant, in an ideal world, you should be able to turn, the claim comes from your client to you. You say, oh, this is a problem with my sub-consultant. You turn to that sub-consultant and say, this was your issue. Please report this to your insurance carrier and deal with it. And in an ideal world, they will have adequate insurance and they will be able to either defend it or pay the damages. Unfortunately, what can frequently happen is you turn to your sub-consultant and they might say, yeah, well, we had insurance when you retained us 3 years ago, but insurance got expensive, or we had so many claims that no insurance company wanted to insure us anymore, or we had so many claims that policy that we had this year has already been depleted, so we don't have any insurance. Whatever the reason is, if they don't have insurance available, and if they perhaps can't come up with the finances outside of having insurance, you're going to be responsible for those damages because you're the one that retained them. The client, you're the one that's got the relationship and the contract with the client. So you're going to have to pay those damages. Now, the good news is that our policy, the Shinra policy of professional liability insurance, does have coverage for your vicarious liability. We're not insuring your sub-consultants, but you do have coverage if you have to pay damages because your sub-consultant isn't able to do it. And then we'll try to work together to get that money back from your sub-consultants. I would also say if you're a sub-consultant and you're working for a prime, you want to equally make sure that they have adequate insurance. Because even though you don't have vicarious liability for them, if they don't have adequate insurance and a claim comes down the pike several years down, and they just sit there and say, well, we don't have any insurance or we have very little left in our policy, reality is such that the allegations of that particular claim are going to shift to the parties that have the most insurance available. So to avoid that whole situation, it's best if everybody is on equal footing and everybody has available insurance. So that's something you should consider as well. And when you're hiring subconsultants, make sure they not only have insurance in place when you hire them, but you want to continue on an annual basis to follow up for a certificate of insurance to verify that they are maintaining that insurance. Understand your firm's insurance coverage, the adequacy of your policy limits, the size of your deductible, because those are all factors to consider when making a final analysis on a potentially high-risk project. So proposal phase evaluations, the first one is the scope of service. From a risk management perspective, descriptions of services is the easiest part of the proposal. But one word of caution, most states mandate that a professional cannot perform services that are not within the sphere of your professional competence. That sphere, however, can be enlarged through the use of subconsultants. So we've talked about that. I think we also mentioned the importance of doing full construction phase services. Many years ago, some design firms and some insurance companies thought it was better for a design professional not to be involved during the construction phase, because just the very fact that you were out there was going to lead to more claims that you should have stopped the contractor from building it incorrectly. And yet our statistics show that the opposite is true. There are more claims involved when you're not out there during the construction phase. So you want to be involved in construction phase because let's face it, no set of design documents is ever going to be 100% complete and accurate. And the experience and ability of contractors varies greatly. If the contractor has any questions about how to build that project, it's better to get them answered before they start construction, rather than have them build it wrong and have to then tear it down, and that could drag you into litigation as well. The other problem is if you're not being hired for construction phase services and the contractor still has questions about it. I used to always get phone calls from our insurance saying the owner wouldn't pay me to be out there, and yet the contractor's calling me every other day and asking questions. And that puts you in a real quandary because you don't want to do work for free, but on the other hand, you don't want if you're knowing the contractor is going off in the wrong direction, you don't want the project being built incorrectly. So you need to have a conversation at that point with your client and get out there on the project. One last word about construction phase services is it's better to provide no services than to provide limited services. If the client is only willing to pay you to be out there on a very limited basis, that can greatly increase your risk because you're out there just enough to have responsibility, but you're not out there enough to really take control and know what's going on and meet the standard of care adequately. So stay away from limited construction phase services. The adequacy of project information. Typically, information provided by your client should include a program that sets forth their objectives, the schedule, constraints, criteria, including special equipment, systems, site requirements, etc. Under the standard form agreements, the AIA and the EJCDC documents, clients are expected to provide surveys, legal limitations, and utility locations for the site and geotech services. When the project scope and the schedule and the budget are determined early, claims and disputes are minimized. Is the fee adequate? If you're getting too little compensation, that can result in a tendency to take shortcuts, and that can lead to mistakes or a lack of proper coordination and communication with the consultant's client and contractor. You need enough fee to pay your salaries and not affect quality. You need to be realistic here. Consider whether the fee covers your costs and provides a profit. And are there provisions for additional services? Because obviously most projects change not only during the design, but also during the construction phase. So you want to make sure that there's a contingency and that the client has enough money set aside. Time and budget. Rushing to comply with an unrealistically short deadline will increase the likelihood of design errors and omissions, which can lead to construction defects and deficiencies. An unreasonably short construction schedule can also lead to construction defects and deficiencies. It might even slow down the project as trades overlap in congested areas, which adversely affects efficiency. Be certain that your client understands that the construction budget is not the same as the project budget, which should include soft costs for things like fees and interest, etc. If the budgets are inadequate, the project may be abandoned, you may not be fully paid, or litigation may result. And then we get to the contract terms and conditions. As I said, there's a real dilemma here because many proposals contain these proposed terms and conditions. And the dilemma is if you're asked to indicate which provisions you take exception to, you don't want to put yourself in a position where you're downgrading your opportunity to get the job. Not all provisions are deal breakers. Some are more important than others. So you don't want to be eliminated too early just because you've got some objections to precise terms without an opportunity to really negotiate directly with the client. Now, we have other seminars that go into a lot more detail regarding contract provisions and how to negotiate contracts. So for this provision, I'm really just going to focus on what to look for in a contract that may increase your risk on a specific project. So this is going to be kind of a higher level look at that. But the important ones these are the ones you want to be alert for. Indemnification. What is indemnity? Indemnity is an agreement where one party agrees to accept responsibility for the damages incurred by another party. If you think about it, your insurance policy is an indemnification or an indemnity agreement. You pay us a premium, and then we agree to step into your shoes to pay the damages on your behalf. So clients often want to be indemnified for damages that are caused as a result of your negligence, and that's not unreasonable. There does not need to be a written indemnification in an agreement for that concept to apply. Under common law, if your negligence contributed to damages that your client is responsible for, you have legal liability for that. So just look at when indemnification provisions are written by your clients, they typically tend to be very much broader than what is required under common law and may result in exposures that you don't have insurance for. So what you want to look at is, does the provision exceed your normal legal liability and your insurance coverage? And your normal legal liability is to be responsible for damages to the extent caused by your negligence. That's it. It's a very simple standard. You want to make sure that there's no defense obligation. Professional liability insurance policies will defend you, but there's nothing in the policy that will provide a defense for your client. We will reimburse the client if those damages are the result of your negligence and they're recoverable under law in that jurisdiction. You don't want to agree to an upfront defense because that can possibly result in an uninsurable exposure. Warranties and guarantees. A warranty or an express warranty or guarantee is a promise that a given event is going to occur. And if that given event doesn't occur, the client can come after you for breach of that promise. Under U.S. common law, there is no requirement that design professionals warrant or guarantee either their services or the work of the contractor. Again, the common law ties it back to you have an obligation to meet the professional standard of care. Failure to do so is negligence, but you are not required to warrant or guarantee your services. So when you see the words warranty and guarantee in contracts, it should be a big red flag. You want to look at what is it that they are asking you to warrant or guarantee. And keep in mind that warranties are tricky. They can be created without even using the word warranty. I always look at what we call the sure words: insure, assure, ensure. For example, design professionals shall ensure that there will be no defects in the construction of the project. That's a guarantee of contractor's performance. That is not something you want to agree to. It's beyond what the law requires of you, and it's beyond what you have insurance for. Time limitations. Many clients may impose time limitations or late performance penalties. You'll often see language in a contract that says time is of the essence. That can convert any delay into a claim for breach of the agreement or even termination of the project. Again, you should be agreeing to perform your services as expeditiously as is consistent with the professional standard of care. You can't agree absolutely to meet a schedule because there are too many unknowns, things that are outside of your control. You should only be responsible for delays to the extent that they're caused by your negligence. Liquidated damages sometimes, are required in contracts, especially if you're working for a contractor or a design builder. They have to pay liquidated damages, but the law does not require design professionals to, and professional liability insurance policies specifically exclude claims for liquidated damages. Again, you want to tie that to the standard of care. Speaking of the standard of care, you want to make sure that the client is not increasing the standard of care contractually. The standard of care is based on doing what another design professional in the same profession, in the same location, on a similar project at the same time would have done. It's what's known as the ordinary standard of care. So look out for words where you might see that you shall perform to the highest professional standards. That basically is a requirement that you're going to be perfect, and if you're not perfect, the client can come after you. And verification of client supplied information. I just saw this in a contract I reviewed this morning. Sometimes a client will provide information but won't allow you to rely on its accuracy or completeness. And if the information is old or suspect, it may be prudent for the client to pay to have the information verified. Your client may or may not do so, but you shouldn't be required to be responsible for the accuracy or completeness of information that you didn't generate or verify. Client should be responsible for the risks associated with deficiencies in the information that they give you. You should be entitled to rely on that information. So if you remember that the proposal stage is the beginning of contract negotiations and you respond with the appropriate level of detail to proposed terms and conditions, you'll stand a better chance of not being eliminated from consideration and prejudicing future specific contract negotiations. One last word about well-written proposals. A proposal is many things, not the least of which is a roadmap for the project. It's an opportunity to think about the project, the how, when, and under what circumstances the services are going to be provided. It's the opening stage of contract negotiations. It's an opportunity to address the known client terms and conditions that are objectionable in a very broad way. So despite the excitement to obtain the job, remember, don't oversell your firm, the quality of the services, or the results to be obtained. It's generally best to guard against what we call puffery in terms of your firm's capability or overcommitting your firm's people or resources. You don't want to make projects or promises, you don't want to make promises that can't be kept or expectations that can't be fulfilled. So even if you're not legally binding as in a contract, clients have a tendency to remember what they were promised and very disappointed if promises aren't fulfilled. So it's better that proposals begin to foster in your client a realistic sense of what is possible and begin the ongoing task of managing and fulfilling your client's expectations. Do have a written agreement. It's not a good idea ever to start work on a handshake. Sometimes you may decide to provide services prior to the execution of a formal written agreement. Even then, it's a good idea to have at a minimum a record of the arrangements with your client. This can be a so-called commitment letter or a letter of intent, and the content may vary depending on the stage and the content of prior communications. But it's really smart not to start performing services if your client is expressing any reservations about the scope of your service or the proposed compensation. These issues really should be further discussed and addressed before you proceed. If the scope and the fee are resolved and you're still negotiating perhaps just some of the terms and conditions, you could negotiate a letter authorizing you to begin services for a limited period of time. You might even want to identify the one or two provisions that still need to be finalized, while others apply to the services being performed under the letter. If the proposal includes a scope of service but the fee is at issue, consider obtaining an authorization to proceed with compensation based on time expended at your normal billing rate, a multiple of salary, or some other basis. It's probably best not to provide services for more than 30 days unless there's a good reason to extend it. Provide an incentive to negotiate and execute the formal agreement promptly. As they say, if you have an oral agreement, it's not worth the paper it's written on. It makes it very difficult, if not impossible, to defend you when a claim comes in. Not a good idea. So finally, in summary, the essence of risk management lies in maximizing the areas where we have some control over the outcome while minimizing the areas where we have absolutely no control. And the ways in which to accomplish this are to select projects that match up with your qualifications, your experience, and your staffing. Select clients carefully using your due diligence. Provide continued training for your staff on contracts and risk management topics, and our Schinnerer School of Risk Management can help you do that. Provide timely identification, management, and resolution of problems. Don't avoid them. Avoiding a client complaint or a potential liability problem will not make it go away. Have contractual risk allocation provisions if you can, such as a limitation of liability or an indemnification running in your favor. They're helpful, but alone they're not the answer. And similarly, although insurance is an essential risk transfer mechanism, it's not a substitute for a comprehensive risk management program. So I hope you've found this information helpful. For more information, we urge you to visit our website. Here's a look at our new risk management website. If you haven't already established an account, you should do so. You can click on that. I think under webinar registration, there's a form on set up an account. And again, you've got claim studies, management advisories, benchmarking information, contract language assistance, and past webinars, which can now also provide continuing education credits for you, and a lot more.